back and forth was heard by the Commission between the controversial SABC and Multichoice deal signed in 2013. The deal helped the public broadcaster introduce its 24-hour news channel. But according to the former Communications Minister, Yanis Karim, who appeared before the state capture inquiry, the deal was irregular and unlawful.
Never a board decision to support STB control, according to Ms. Nolotando Kosa, according to what I gather Mr. Krishnaidu says, until much later.
Argued that the SABC could not support encryption, which amounted to capture, and also blamed Multichoice of frustrating the digital migration process.
This is a very clear example of regulatory or policy capture, whereby irregular means you shape a government policy. Because, Chairperson, there is absolutely no reason to include in a commercial transaction between the SABC and DSTV a clause that deals with government policy. You cannot encrypt.
At the same time, former SABC CEO Lulama Mokobo told the Commission that she did not agree with the signing of the controversial 553 million rand deal. Mokobo said because the process was flawed. She testified that she was unhappy with some of the clauses that dictated that the broadcast not support set-top box encryption. Mokobo told the Commission that digital terrestrial television implementation was hijacked by Multichoice.
Way that I could have sat there and agreed that the law be broken. A policy statement from government becomes law. There was no way I could have been party to that happening. So that meeting had discussed quite intensely. It was, shall I say, there was a little bit of camaraderie in that meeting. There was a little bit of joking backwards and forwards.
Between Multichoice and SABC.
But there was absolute clarity on things that should not have been in discussion.
Yes.
As being included in the contract. Therefore, it was quite surprising when I read the letter that they sent to Mr. Mutwening, that those clauses were still there.
Notando Makutulela, SABC News, Johannesburg.